Judge dismissed black lawyer's argument without looking. Attorney General walked in and asked her to continue. "Counsel, I've heard enough." Judge Raymond Hargrove did not look up when he said it. He was signing something at the bench, his pen moving in slow, deliberate loops across the corner of a document that had nothing to do with the case in front of him. The courtroom was full. 37 people in the gallery, 4 attorneys at the adjacent table, 2 clerks, a bailiff near the door who studied the ceiling with the practiced blankness of a man who had learned not to see certain things. The woman standing at the podium had been speaking for 11 minutes. Her brief was 74 pages. Her oral argument was on page 3. "Your Honor, I would respectfully request the opportunity to complete my—" I said I've heard enough. He set down his pen and looked at her then, for the first time since she had stood up. The look lasted exactly 1 second. "The motion is denied. We'll take a 15-minute recess." He stood. The bailiff called the room to order. And Jordan Elise Whitmore gathered the pages of an argument she had spent 4 months preparing, stacked them quietly at the edge of the podium, and stood still for a moment, with both hands pressed flat against the wood. Nobody in that gallery said a word. But she was not looking at any of them. She was looking at the back of the door the judge had just walked through. And what was in her eyes was not tears, and it was not anger. It was something much more patient than either of those things. Man. She really had no idea who she was dealing with. Judge Hargrove thought that recess was the end of the conversation. It was not the end of anything. It was the beginning of the last thing he would ever do from that bench. Let's get into it. Jordan Elise Whitmore was born in the back bedroom of a shotgun house on Delmar Boulevard in St. Louis, Missouri, in a neighborhood where the closest thing to a law library was a paperback copy of Your Rights, taped to the inside of the community center's front door. Her mother, Gloria Whitmore, worked the overnight shift at a commercial laundry facility 6 days a week, pressing hospital linens for $8.30 an hour. On the 7th day she went to church, not because she had surplus energy, but because, as she told Jordan from the time Jordan could understand sentences, faith was not optional when you lived at the margin. It was the margin itself. The house had 3 rooms and a bathroom whose floor tiles had been cracked since before Jordan was born. The kitchen window had a screen that didn't quite fit the frame, and in the summer the mosquitoes came in, and in the winter the cold came in. And Gloria had duct-taped a piece of heavy plastic over it that stayed there for 11 years. Jordan did her homework at the kitchen table under a lamp with a 40-watt bulb because 60-watt bulbs cost more on the electric bill. The table rocked slightly when she wrote, one leg shorter than the other, and she had folded a piece of cardboard and wedged it under the short leg sometime in the 4th grade. And it was still there in the 8th grade, gone soft now with moisture and time, still doing its job. She did not know for a long time that this was unusual. It was simply the condition of things in the place where she learned things. What Gloria gave her daughter was not money, and it was not connections, and it was not a neighborhood that believed in her. What she gave her was a single conviction, delivered in the same flat, certain voice she used to discuss everything from rent to weather. "Jordan," she said, "the law is the most powerful thing ordinary people ever built. You learn it and you own it, and nobody can take that from you. Not ever." Gloria had wanted to be a lawyer herself. She had taken 2 semesters of pre-law at a community college before her own mother got sick and the money stopped. She had a thin green notebook from those 2 semesters, filled with lecture notes in handwriting so small and precise it looked typeset. She kept it in the drawer beside her bed. When Jordan was 9 years old, she found it and read every page, twice, and then a 3rd time with a dictionary beside her for the words she didn't know. She never put it back in the drawer. She kept it. She kept it in her own bag through middle school and high school. A little more worn each year, the cardboard cover gone soft at the corners. The spine cracked from being opened and closed so many thousands of times. She read it the way other people read a letter from someone they loved. Not to learn new things, to remember who had held it first and why and what it had cost. By the time Jordan was in high school, she was reading federal case law for the same reason other kids read novels. Not for school, not for a grade, because it was the most interesting thing she had ever found in a building she had free access to, and that building was the public library on Olive Street. And she went there every day after school and stayed until the lights flickered at closing. Time. The librarian, a soft-spoken man named Mr. Abernethy who wore the same cardigan in 3 different colors on rotating days, started leaving things on her usual table. A volume of the Federal Reporter, a biography of Thurgood Marshall, a paperback guide to constitutional law. He never said why. He just left them there. She never said thank you. She just read them. They both understood the arrangement perfectly. Jordan won a full scholarship to Washington University in St. Louis. She studied political science and pre-law and graduated in 3 years because she tested out of more credits than the registrar had ever processed. In a single application, she was 20 years old. She took a bus to New Haven, Connecticut with 2 bags and a green notebook with someone else's handwriting in it. And she walked into Yale Law School on a full merit fellowship that had been endowed by an alumna who had also grown up in a house where the cold came in through a window that didn't fit. She finished second in her class. She clerked for a federal circuit judge for 2 years. She spent 4 years as an assistant United States attorney in the Eastern District of Missouri, where she tried 31 cases and lost 2. And one of the 2 she lost, she appealed and won on a question of evidentiary procedure that a law review at Georgetown later cited as a foundational analysis of the Fourth Amendment's application to digital search records. She was not celebrated for any of this in the rooms where she did it. She was noticed the way a useful tool is noticed. She did not require celebration, she required results. Then she left the government, which surprised everyone who knew her, and she opened a small practice in St. Louis with a borrowed office space and a second-hand desk and a client base that consisted at first of exactly nobody. She built it. By the time Jordan Whitmore walked into the Sixth Circuit courtroom in the Eagleton Federal Courthouse in St. Louis on the morning of October 14th, she was 38 years old, and she was the founding partner of Whitmore and Associates, which was not large and was not glamorous and was not the kind of firm whose name appeared in the financial press. But it had a reputation, earned one case at a time in courtrooms exactly like this one, for never taking a case it didn't intend to win. The case she was arguing that morning involved a school district in rural Jefferson County that had systematically underfunded its special education services for 11 years, redirecting earmarked federal funding to a new athletics complex, and had covered the paper trail with a filing system so deliberately convoluted that 3 previous attorneys had walked away from it citing cost. Jordan had not walked away. She had spent 4 months inside that filing system. She had found the buried disbursement records. She had mapped every dollar. The brief she carried to the podium that morning was 74 pages long, and it was airtight in the way that only something built by someone who has nothing to lose and everything to offer can be airtight. Judge Raymond Hargrove had been on the federal bench for 19 years. He had been appointed by a governor who was later convicted of wire fraud. In those 19 years, he had developed a well-documented reputation in the local bar association for what colleagues described privately as a certain procedural impatience, which was the polite term for a behavioral pattern that looked, when you examined it across the span of his docket, like something considerably less polite than impatience. He was the kind of judge who completed other paperwork during oral arguments, the kind whose clerks had learned to prepare case summaries in bullet points no longer than 2 lines, because anything longer risked not being read. He moved his docket efficiently, which was the metric by which his performance was measured. And efficiency, in a courtroom, can be indistinguishable from dismissal if you are the one being dismissed. Jordan knew his record. She had read every published opinion he had authored in the past decade. She had prepared for every objection, every redirect, every procedural maneuver in his known repertoire. What she had not prepared for was a judge who would simply stop listening. The recess lasted 17 minutes, not 15. Jordan sat at the plaintiff's table and did not move. Her second chair, a third-year associate named Marcus Webb, who had never seen a federal hearing before this one, was very carefully not saying anything. He understood, without having to be told, that this was not a moment for words. He had his pen in his hand, but he was not writing. The pen was simply somewhere for his hand to be. The gallery had thinned a little. A few of the spectators who had come in off the street had drifted out during the recess, but most of the seats were still filled. The parents of the children the case represented were there. 7 of them had driven more than an hour to be present. Some of them had taken unpaid time from work. One of them, a woman named Vera Simmons, whose 10-year-old son had not received a single hour of his court-mandated occupational therapy services in 3 years, had worn her church clothes, a navy dress with a small white collar, heels that cost her something she couldn't easily spare. She had done this not because she thought the judge would notice, but because she believed that a room where something important was being decided was a room worth dressing for. Against the far wall of the gallery, in the last row, a woman who looked to be in her late 60s sat with her hands folded in her lap and her eyes on the back of Jordan's head. She was wearing a gray coat that had been carefully pressed. She had taken the Metrolink from the south side of the city at 6:30 that morning, to be here by 9. She had not told Jordan she was coming, because she knew Jordan would have told her not to bother, and she intended to bother. Her name was Gloria Whitmore, and she had brought, in the canvas bag beside her foot, a thin green notebook with a cracked spine and handwriting inside it that she had carried for 30 years. When Hargrove returned to the bench, he settled into his chair with the air of a man returning to an interrupted meal. "We'll resume," he said. "Counsel for the plaintiff. You had the floor." Jordan rose. She returned to the podium. She found her place in the brief and she began again, from the paragraph where she had been stopped. She spoke for 40 seconds before Hargrove interrupted. "Counsel." His voice carried no particular inflection. It was the voice of a man who had developed, over 2 decades, the ability to communicate contempt without technically expressing it. "The court has significant reservations about the evidentiary foundation of this argument. Your Honor, if I could direct the court to Exhibits 12 through 19, the disbursement records. The court has reviewed those exhibits. With respect, Your Honor, Exhibits 17 and 18 were only submitted to the record last Thursday. The court's review, counsel." He said the word the same way a person sets something heavy down on a table, flat, final. "Are you suggesting that this court has not done its due diligence?" The room went very still. Nah, hold on. That right there is what you call a trap. If she says yes, she's in contempt. If she says no, she surrenders the argument. She is standing in a room that was designed, over 19 years, to make exactly this moment feel like the only available outcome. Let's see what she does. Jordan let 2 full seconds pass. Not because she was flustered, because she was choosing. "Your Honor, I am suggesting that the record contains material the court may not have had opportunity to fully review given the submission timeline, and I believe the court's decision will be better informed if I am permitted to address those materials directly." Hargrove looked at her. The look lasted longer this time. Something behind his eyes shifted, almost imperceptibly, in the direction of something that might have been calculation. He was not a stupid man. He was a man who had operated in a room where calculation had, for 19 years, produced predictable results. "The court will take that under advisement," he said. "The plaintiff's motion for injunctive relief is denied pending full briefing. Counsel, you may sit down." She sat down. Marcus beside her kept his eyes on the table. His jaw was tight. He had gone to law school precisely because he believed in rooms like this one, and rooms like this one were currently in the process of teaching him something about belief that he was not ready to learn yet. Jordan opened her legal pad to a clean page and wrote 3 words in her careful, exact handwriting. She did not underline them. She circled all 3. Then she turned to the next page and began outlining her appeal. It did not end that morning. The court's denial of the emergency injunction meant that the Jefferson County School District could continue operating its special education program in its current form while the full briefing process played out, which, at the pace Hargrove's docket typically moved, meant a minimum of 8 months. 8 months during which 31 children with documented disabilities would continue to receive no services, or inadequate services, under a program that had been draining federal money into an athletic facility for 11 years. Jordan filed for expedited review. Hargrove denied expedited review. His written order on the denial was 4 sentences. It did not address any of the specific grounds she had cited. 3 weeks later, she filed a motion to reconsider, a formal procedural tool specifically designed for situations where new evidence or changed circumstances warranted the court's re-examination of a prior ruling. It was not an improper filing. It was not a frivolous filing. It was, by any conventional legal standard, a reasonable next step given the progression of the case's evidentiary record. Hargrove denied it in 11 days. In the written order, he included a footnote. The footnote read, "Counsel is reminded that persistence in filing motions the court has already addressed may be construed as an improper attempt to relitigate decided matters." Marcus printed the order and brought it to Jordan's office and stood in the doorway with the expression of a man who has just witnessed something he does not have a framework for yet. His face was the face of someone encountering, for the first time, the difference between what the law is supposed to do and what a room full of its practitioners sometimes allows it to do instead. He put it in a footnote, Marcus said. "I know, that's not a legal argument, that's a message." "I know, Jordan, he's Marcus." She took the order from him and set it on the stack of documents on her desk, which was already 14 inches high. "Get me the docket history for every civil rights case Hargrove has adjudicated in the last 10 years. Every case where opposing counsel was a black attorney. I want the resolution times, the motion denial rates, the average number of interruptions during oral argument as documented in the hearing transcripts, and any footnotes. All footnotes." Marcus looked at her. He was quiet for a moment. "That's going to take. I know how long it's going to take." He left. She turned to her window. The parking structure across the street had a brick face stained with exhaust and weather in long, gray streaks that ran from the top stories to the bottom like something that had been crying for a very long time, or like water finding the path of least resistance through a surface that was supposed to be solid, which was not so different. She had been here before. Not in this exact building, not with this exact judge. But she had been in the territory of this experience many times, in many forms. Since the first day she walked into a professional space and waited to be told, by the space itself, whether she was welcome in it. A professor in law school who directed questions to the 2 seats on either side of her, and never to hers. A supervising attorney in her first AUSA year who carbon-copied every email she sent him to a colleague without ever explaining why, as though her work required a second set of eyes that her white colleague's work did not. A courthouse clerk who had asked, on 4 separate occasions across 3 years, whether she was there to drop something off or to be admitted to the bar. The territory was not the destination. The territory was the work. You could either let the weight of it bend you toward accommodation, or you could let it feed the precision that you brought to every brief, every exhibit, every motion. The precision of someone who knows that the margin for error available to her is smaller than the margin available to the person trying to stop her, and has decided to use that asymmetry rather than resent it. She picked up the phone and called the Missouri Attorney General's office. Not to file a complaint. Not yet. She called a career attorney in the Civil Rights Division named Leonard Chung, whom she had known since their clerkship days, a man with a reputation in the office for the same quality she valued in herself. Patience that looked, from the outside, like stillness, and was actually preparation. She asked him a question. It was not about the case, and it was not about Hargrove, and it was not exactly about anything she needed to explain in terms he couldn't already hear beneath her words. Leonard Chung listened to the question. He was quiet for a moment. "Are you serious?" he said. "I'm always serious, Leonard." Another pause. "Give me 72 hours. She gave him 72 hours. What Jordan had not disclosed in any court filing, and what Judge Hargrove had no way of knowing, because it had not been submitted to the record, was that 4 months earlier, while excavating the Jefferson County School District's financial records, she had found something that did not belong to her original case. It was a set of internal communications between the district's former superintendent and a state-level official in the Missouri Department of Education. The communications spanned 6 years. They were not labeled or organized in a way that suggested anyone expected them to be found. They had been stored in a nested subfolder of a subfolder in the district's digital records archive, inside a directory called Facilities Infrastructure, which was itself inside a directory called Capital Projects 2014, which was itself inside a drive that the district had been legally required to produce in response to Jordan's document request, and had produced, apparently without reviewing its complete contents. The communications documented a pattern of deliberate misdirection in federal special education, funding that was not limited to Jefferson County. It touched 4 other districts. The total sum involved was not hundreds of thousands of dollars. It was, when Jordan fully tabulated it across the 6-year span in 5 districts, $11.3 million of federal funding that had been systematically misapplied, documented in real time by the two men who had arranged it, with the casual confidence of people who expected the conversation to stay private. Forever. Jordan had known about this for 4 months. She had told no one except her malpractice insurer and one colleague at the Bar Association. In the most general terms, because what she had found required a chain of custody before it could be introduced in any proceeding without being challenged on authenticity grounds, and building that chain required forensic document examination, whistleblower interviews under counsel, and the kind of methodical, unglamorous work that does not look like anything from the outside and feels, while you are doing it, like assembling a structure in the dark, using measurements you took in the light. She spent those 4 months building that chain, in her evenings, after the rest of the office had gone home. At the kitchen table of her apartment with a 40-watt lamp, which she had kept as a fixture in every home she had lived in since Delmar Boulevard, not as sentimentality, but as something she could not entirely explain, except that it had been the light under which she learned everything, and she found that she still thought more clearly under it than under any other kind. The morning after Leonard Chung's call, she drove to a FedEx store in Clayton and shipped a sealed copy of the complete documentation package to the United States Department of Justice, Disability Rights Section. She kept the tracking number. She kept the receipt. She kept a copy of everything in a fireproof cabinet in her office and a second copy in the safety deposit box at the credit union on Grand Avenue, where Gloria Whitmore had kept her savings for 40 years. Then she went to court. Leonard Chung called back in 68 hours, not 72. "You need to be in the courthouse on Thursday," he said. "I have a hearing Thursday." "I know you do." She understood then. She understood it completely. She sat with what she understood for a long moment. "Leonard," she said. "Who authorized it?" He named the name. Jordan repeated the name to herself in the quiet of her office, not aloud. The name was the name of a person in a position that had the standing and the visibility and the institutional gravity to walk into a federal courtroom and change the quality of the air in it simply by arriving. A person who had read the docket recording that Jordan's formal clerk request had enabled. A person who had watched, on that recording, a judge sign something unrelated at his bench while a woman with a 74-page brief stood at a podium on page 3. She thought about Vera Simmons in her navy church dress. She thought about 31 children who had been waiting for services that a legal filing system had been designed to make unreachable. She thought about a green notebook, about the weight of a 40-watt lamp, about the sound of an argument being stopped before it could finish itself. She called her mother. Gloria Whitmore picked up on the second ring. "Baby," she said. "Thursday," Jordan said. "Same courtroom. Be there." A pause. Not a surprised pause. A knowing pause. Gloria Whitmore had lived long enough inside the long arc of her daughter's work to understand the specific weight of a sentence like that one. "The last row again? The last row again. I'll press my coat. Yo. I need everybody to fully understand where we are right now. Because the judge thinks this is over." He wrote a footnote telling her to stop filing motions. He denied the injunction. He denied expedited review. He has done everything within his procedural authority to make Jordan Whitmore's argument simply not exist. But she has been building something for 4 months that nobody in that courthouse can see. And on Thursday morning, she is going to walk through those doors with everything she built. Let's see what a room looks like when the ceiling comes off. Thursday morning in the Eagleton Federal Courthouse was overcast and cold. The kind of October day that makes the gray stone of federal buildings look like it grew there naturally, like geology rather than architecture. Jordan arrived at 7:40, an hour before the doors opened to the public, and she sat in the parking garage for 11 minutes without moving. She was wearing a charcoal suit she had bought the day she passed the bar. It had been altered twice since then as her frame had changed with the years, but it was the same suit. Her mother had ironed it the night before, in Jordan's apartment, while Jordan reviewed her notes at the kitchen table, under the 40-watt lamp. Gloria had done the ironing with the serious attention she brought to everything that mattered, pressing each seam with the heel of the iron in the particular way she had developed at the laundry facility over 30 years, the way that makes a garment lie perfectly flat and hold its line through a full day, through a room's worth of scrutiny, through whatever the room decides to do. Marcus was already in the courtroom when Jordan arrived. He had been there since 7:30. He had arranged the exhibits in the exact order she had specified, numbered and tabbed, the binder's spine perfectly aligned with the edge of the plaintiff's table. He had checked the courtroom's audio recording system, which Jordan had formally requested be activated for the morning's proceedings, a request that had been grudgingly granted by the clerk's office with no explanation required. The request was standard procedure. It was also, in this particular case, something more than standard procedure. The gallery began filling at 8:15. The 7 parents were there again. Vera Simmons was in the second row this time, not the fourth. She had brought her son, a round-faced boy with wire-rimmed glasses, and a backpack that had a small iron-on patch shaped like a space shuttle on the front pocket. He sat very still beside his mother and looked at the room the way children sometimes look at rooms that adults have given complicated weight to, with a patient openness that has not yet learned to be guarded. At 8:40, 2 people Jordan did not recognize entered through the side door that led to the courthouse corridor. They were both in dark suits. They sat in the third row on the left side, close to the aisle. One of them carried a leather portfolio and was writing before she sat down. The other carried nothing, but had the look of someone accustomed to rooms where what you carry is not the point. Jordan noted them. She set her binder on the table. She did not react. At 8:55, Hargrove entered. He took his seat with the same deliberate gravity that had characterized his every movement in her experience of him. He arranged his papers. He acknowledged the bailiff. He glanced at the plaintiff's table with an expression that suggested the plaintiff's table was a recurring inconvenience he had, through long practice, learned to absorb. "We're back on the record," he said. "Whitmore versus Jefferson County Unified School District. Plaintiff's counsel. I'll remind you that the court has already addressed the motion for injunctive relief, and today's session concerns only the scheduling of full briefing." Jordan stood. "Your Honor, before we address scheduling, I would ask the court's permission to introduce 2 additional items into the record." Hargrove looked at her. His expression was the expression of a man who has ordered a specific meal and been told again that what has arrived is something else. "Counsel, this is a scheduling conference, not an evidentiary hearing." "Yes, Your Honor. The items I wish to introduce relate to the scope of the case as it now exists, which may affect the scheduling parameters the court is considering. The scope of the case as it exists has been established by the pleadings. The scope of the case as it exists this morning is materially different from the scope established in the pleadings. New evidence has emerged since the filing of the original complaint. A sound from behind her, from the direction of the side door. It was not a loud sound. It was the particular sound of a door opening, with an authority that requires no announcement. The way a pressure change in a room announces itself not by noise, but by the way everyone in the room slightly adjusts. The kind of entry that changes the quality of the air. Judge Hargrove's eyes moved from Jordan to a point somewhere over her left shoulder. His expression changed, not dramatically, not in a way the gallery could have fully named, but in the specific, observable way of a man who has just registered a presence in his courtroom that he was not expecting and cannot, by any available procedural maneuver, simply dismiss. Jordan did not turn around. She waited. The footsteps crossed the well of the courtroom, past the bar, and stopped 2 feet to her left. "Your Honor." The voice was measured, precise, and carried the practiced calmness of someone who never needed volume to establish authority. "I apologize for the informal entry. I'll be brief." Hargrove's pen was very still. "Attorney General Renee Alston, Missouri Department of Justice. I'm here in an oversight capacity related to matters that intersect with this proceeding. I'll note for the record that the United States Department of Justice, Disability Rights Section, has formally opened a parallel federal investigation within the last 48 hours. Counsel for the plaintiff in this matter has cooperated fully with that investigation, and the materials she has brought to this courtroom today are central to its scope. I would ask the court's permission to observe the remainder of this morning's session, and I would respectfully request that counsel for the plaintiff be permitted to complete her argument on the evidentiary matters she has raised." The room held itself completely still. Vera Simmons pressed both hands flat against her thighs and looked at the back of Jordan Whitmore's head. In the last row, Gloria Whitmore's hands tightened around the strap of a canvas bag, and her chin lifted a fraction of an inch. Hargrove cleared his throat. The sound was very small in the room. "Counsel," he said, and the word was directed at Jordan now, and it had in it something that had not been there before. A new careful quality. The quality of a man doing arithmetic in real time, and not finding the numbers he expected. "You may proceed." Jordan opened the exhibit binder to the first tab. She had been waiting 4 months to say what she said next. She said it without preamble and without any of the apologetic hedging that the room had, until 45 seconds ago, required of her. "Your Honor, the Jefferson County Unified School District has, over the course of 11 years, redirected approximately $4,200,000 of federal special education funding, designated under the Individuals with Disabilities Education Act, to the construction and maintenance of its athletics complex. The original pleadings document that pattern with respect to the district's internal budget. What I would like to introduce this morning are Exhibits 80 through 94, which document that this pattern was not an isolated district-level decision. It was part of a coordinated misdirection scheme involving at minimum 5 districts and at minimum 1 official within the Missouri Department of Education, spanning 6 years, totaling $11.3 million. She placed the first exhibit on the document camera, a spreadsheet. 72 rows, each row a transaction, each transaction documented with a date, a source, a destination, and an authorization signature that appeared, in 16 of the rows, under the same name. The name was a name that the 2 individuals in the 3rd row both wrote down. Exhibit 80 is a digitized copy of internal communications obtained from a whistleblower source within the Jefferson County District. The chain of custody documentation for this exhibit is contained in Exhibit 81. The communications were authenticated by a forensic document examiner whose credentials and analysis appear in Exhibits 82 and 83. She moved to the next tab. Exhibit 84 is a recording. It is 41 minutes and 17 seconds long. It was made by a current employee of the Jefferson County District's Administrative Office, without the knowledge of the other parties, which is lawful under Missouri's one-party consent statute. In this recording, the district's former superintendent and the individual whose name appears in the authorization column of Exhibit 80 discuss, in specific terms, the mechanism by which the redirections were categorized in the district's federal reporting structure to avoid audit flags. She pressed play. The recording was not dramatic. It was 2 men talking in what sounded like a conference room with fluorescent lighting. The particular flat buzz of fluorescent lighting faintly audible beneath their voices, in the businesslike cadences of people who have discussed the same thing many times. But the words were clear. The system they described was clear. The shared understanding that what they were doing was improper, and that the reporting structure had been deliberately engineered to conceal it, was as clear as anything Jordan had ever heard in a courtroom. 41 minutes and 17 seconds. Every parent in the gallery listened. Vera Simmons did not move. Her son had stopped looking at the ceiling. He was looking at his mother's face, reading it the way children read faces. When they need to know how to feel about something they cannot yet understand on their own. When the recording ended, the room held its silence for a moment longer than it needed to. Marcus watched the judge's face during the recording. What he saw there was not guilt, because Hargrove was not implicated in what the recording revealed. He had not been party to the scheme. What he saw was something more complex. The face of a man registering, in the presence of an attorney general, and the implied presence of the federal Department of Justice and 41 minutes of recorded audio, that the procedural impatience he had applied to the woman at the podium had not, as he had apparently assumed, made the evidence go away. It had simply deferred the moment when the evidence would speak, in front of an audience whose presence he could not manage with a footnote. Renee Alston, seated now in the front row of the gallery with her portfolio open and a pen moving steadily across its pages, did not look up. Hargrove was very still. "Counsel," he said finally. His voice was careful in a way it had not been in any previous session. Careful in the way of a structure that has been asked to bear more weight than it was designed for, and is deciding, in real time, whether to hold or to give. The court will need time to review these materials. "Of course, Your Honor." Jordan's voice was exactly what it had always been, measured, precise, not triumphant, not relieved. Simply the voice of a person who came to a room to finish a sentence and has done so. I would note, for the record, that the Jefferson County School District's attorneys are currently in possession of copies of all materials I have introduced this morning, which were served to them at 8 a.m. today. I would also note that simultaneous referrals have been made to the Missouri State Board of Education and to the Office of Special Education Programs within the U.S. Department of Education. I see, Your Honor, the 31 children whose services have been withheld under this scheme are still not receiving those services. Every additional month of delay represents, for each of those children, an irreversible window of developmental support that cannot be recovered. The plaintiff renews its motion for emergency injunctive relief and requests that the court consider the full scope of the evidentiary record now before it. Hargrove looked at the exhibit binder. He looked at the Attorney General in the front row. He looked at the recording device on his bench, active throughout the session, per the clerk request he had found routine enough to grant without reviewing its implications. He looked at Jordan Whitmore. The court, he said slowly, as if each word was a step being tested for its ability to hold weight, will grant the emergency injunction pending full briefing. A sound moved through the gallery, not a cheer, something quieter and more durable than a cheer. The sound of people who have been holding something for a very long time and have just been told they can set it down. Vera Simmons covered her mouth with both hands. Her son looked up at her face and then reached over and put his hand over hers, his small palm against the backs of her fingers, a gesture that had in it everything that his 3 years of missing services had not been able to extinguish. In the last row, Gloria Whitmore pressed both palms against her chest, her eyes closed, her lips moving silently once. The canvas bag with the green notebook in it was at her feet, and she could feel, through the bottom of her shoe, the particular slight weight of it, the weight of a thing that had been carried for 30 years, toward exactly this room. Jordan gathered her exhibits. She capped her pen. She picked up the legal pad on which, at the previous hearing, she had written 3 words and circled them all. The 3 words were, "Keep the recording." Renee Alston appeared at her elbow as the gallery began to move. "I watched the first session on the docket recording," the Attorney General said, quietly enough that only Jordan could hear it. "The recording your clerk request enabled. I know. You knew he'd do it again." Jordan slid the legal pad into her bag. "He'd been doing it for 19 years, she said. "I just made sure that this time, when he did it, the room was paying the right kind of attention." She turned toward the gallery and walked through the small gate and up the aisle, and she stopped at the last row. Gloria Whitmore stood up. She was not a tall woman, but she stood with the particular posture of someone who has spent decades carrying things that would have bent other people, and the posture had become, over time, a kind of architecture. Jordan put her arms around her mother and let herself be held, fully, the way she had been learning for 38 years to allow, in the moment after the work is done, before the next work begins. "You finished your sentence," Gloria said. Jordan tightened her arms. "I finished my sentence. In the second row." Vera Simmons was already calling her husband. Her son was looking at the iron-on space shuttle patch on his backpack with the focused expression of a child deciding that the world is, on balance, something he intends to inhabit fully. What happened after was not quick, and it was not clean, and it did not resolve in the tidy 60-day arc of a press release. Real consequences rarely do. But they were real, and they were documented, and they moved through the institutions that had protected what had been done the way water moves through bedrock. Slow, certain, rearranging things permanently. The Missouri Attorney General's office opened a formal investigation into the Jefferson County Unified School District and 4 additional districts within 14 days of the Thursday session. The investigation ran for 11 months and ultimately referred 3 individuals for criminal prosecution, including the former superintendent of Jefferson County and the Department of Education official, whose name had appeared 16 times in Exhibit 80. Both were charged with federal program fraud. Both subsequently entered into plea agreements. The third individual, a current district administrator who had joined the scheme midway through its run and had tried to exit it without documentation, received a deferred prosecution agreement in exchange for full cooperation. His cooperation, over 6 months of interviews, added 17 additional transactions to the evidentiary record. Judge Raymond Hargrove was not charged with any crime. He was not found to have been party to the funding scheme. But the Missouri Judicial Conduct Commission received 6 formal complaints about his conduct in the Whitmore case within 30 days of the Thursday session, 3 of them from members of the bar, 1 from a sitting federal judge in a neighboring district, and 2 from private citizens who had been present in the gallery. The Commission's subsequent review examined 61 cases from Hargrove's docket over the previous decade. It took 4 months. Its published findings documented, in aggregate terms, a pattern of differential treatment in the handling of motions and oral arguments that the Commission described as requiring corrective measures. Hargrove accepted early retirement in lieu of a formal censure proceeding. He issued, as required by the Commission, a written statement. The written statement described Jordan Whitmore's work on the Jefferson County matter as, in the Commission's specified language, thorough. It was the smallest, most reluctant word available in the vocabulary of a man who had been required to use it by a process he could not dismiss with a footnote. Jordan read it once. She set it on her desk for 1 day, and then she put it in the recycling, and she did not look for it afterward. The Jefferson County School District entered into a consent decree that required full restoration of special education services within 90 days, repayment of all misdirected federal funds over a 7-year schedule, and independent monitoring of its special education budget for 10 years. Within 90 days, all 31 children named in the original complaint had begun receiving their mandated services. By the end of the first year under the consent decree, the district had hired 3 additional certified special education specialists, restructured its federal reporting procedures, and created an internal audit mechanism that a National Disability Rights Organization later cited in a policy brief as a model worth replicating. Vera Simmons called Jordan's office the morning after her son's first occupational therapy session. Marcus took the call. He wrote down what she said on a yellow sticky note and left it on Jordan's desk. It read, "He stacked 7 blocks. He couldn't stack 2 before." Jordan pinned that note to the inside of her office cabinet door, where she would see it every morning when she took out her files. The civil settlement that the district reached with the affected families totaled $2,400,000. Jordan's legal fee, under the contingency agreement she had negotiated at the outset of the case, would have been a substantial sum. She negotiated a different arrangement with her clients instead. With their full agreement, the settlement funds were directed entirely to a newly established Educational Equity Foundation, incorporated under Missouri law, dedicated to providing special education advocacy services, free of charge, to families in under-resourced districts across the state. The foundation was named the Gloria M. Whitmore Educational Equity Fund. Gloria found out when Jordan mailed her the incorporation papers. She called at 7 in the morning, which was not unusual for Gloria Whitmore, and she talked for 6 minutes without pause, which was not unusual either. What was in her voice during those 6 minutes did not have an adequate word in either woman's vocabulary, and so neither of them tried to name it. Gloria just talked, and Jordan just listened, and the morning light came through the kitchen window. And the 40-watt lamp on the table was still on from the night before, the way it sometimes was when Jordan had worked through until morning, which was more nights than most people knew. The foundation opened its intake line 8 months after the Thursday session. In the first year, it served 42 families. In the second year, it served 91. By the third year, it had placed, in the hallways and courtrooms, and administrative hearings of 11 Missouri school districts, 23 attorneys who had been trained, in whole or in part, through a fellowship program the foundation ran in partnership with Washington University School of Law. The fellowship was named for a librarian named Mr. Abernethy. Jordan received an honorary degree from that law school the spring after the case concluded. She was asked to address the graduating class. She spoke for 12 minutes, which was shorter than most commencement addresses, and she said at the end of it, one thing that the school's communications office printed on a card and mounted in the student lounge. She said, "The law does not care who walked into the room. It cares what happened after." In the third-floor courtroom in the Eagleton Federal Building, in the gallery where Vera Simmons had sat in her church clothes, and her son had put his hand over hers. A framed print now hangs near the window. It was placed there by the Bar Association, and it contains the names of all 31 children represented in Whitmore versus Jefferson County Unified School District in small, careful type beneath a phrase from the Individuals with Disabilities Education Act. Every child, the phrase reads, is entitled to a free and appropriate public education. Gloria Whitmore has seen the print once, on a courthouse visit for a reason unrelated to her daughter's work. She stood in front of it for a long time. Then she sat down in one of the gallery seats, the last row, and she took a thin green notebook from the canvas bag at her side and held it in both hands. And she stayed there like that until the light in the room changed, until the afternoon came in through the window and laid itself across the floor in a long, warm stripe. And then she put the notebook carefully back in the bag and stood up and went home. The cracked spine of it had not been repaired. Some things are held together by being held, and that is enough. Okay, I need a minute here because this one got into me. Jordan at that podium with her argument on page 3 and a judge who wouldn't look at her. The footnote, the denied expedited review, the denied motion. Every tool a room could deploy to make a woman and her evidence simply not exist, deployed, one after another, across weeks. And then Thursday, the door opening, the Attorney General asking her to please continue. Now let me be straight with you before we close out. This story, these names, this courtroom, these specific proceedings, this is fiction. Jordan Whitmore is not an attorney of record in any current filing. We built this narrative with all of that craft and all of that care because the truth it carries is not fictional. There are women in courtrooms right now who have been told the court has heard enough, who are gathering pages at podiums and standing still for a moment with their hands pressed flat against the wood, who have been asked to sit down before their argument was on page 3, who are building chains of evidence in the evenings under lamps that their mothers' hands taught them to work by. And some of them have mothers in the last row with green notebooks in canvas bags. So here is my question for you today, and I mean it. I want to know, has there ever been a moment in your life when someone cut you off? Someone with authority and a room that backed them up, and you had to decide in that exact moment between accepting the stop and finding another way to finish? What did you do? What happened? Drop it in the comments. I read all of them, every single one. If this story meant something to you, hit the like button so this channel can keep building rooms like this one for the people who need to walk into them. Share it with someone who has been handed a footnote instead of an answer. Subscribe if you are new here, because every week we come back to this room and we finish the sentence.